Hopefully you have your lunch in front of you and are excited to learn what is going on with these crazy rescheduling hearings. So hopefully you'll have at least a little bit more information after this presentation. Okay, can everyone see my screen? Thanks for the thumbs up. I appreciate it. Okay, this is a webinar put on by Americans for Safe Access. We were founded in 2002. We are a coalition of healthcare, medical cannabis, and wellness stakeholders that are working to integrate medical cannabis into our healthcare systems. So welcome. Okay, so you guys probably saw the news that the DEA hearings that were scheduled to start next week have been postponed. And I'm going to tell you a little bit about how we got there. Okay, so the process to reschedule any substance starts with either a petition, or Congress can start the process, or in this case, the president um, initiated the process by asking HHS and DOJ to do a review of cannabis. And so the first step is a review that happens at HHS that's conducted by FDA internally. And then they submit that to the Department of Justice that reviews that with the DEA, supposedly. And then the Department of Justice issues a proposed ruling, like if they're going to change the schedule. And then there's a period of public comment. And then during that time, the DEA can elect to hold a hearing to hear more evidence before they make their final ruling. And so where we were right now is that the DEA decided that they wanted to have a hearing. You probably heard the term ALJ. That's it's their internal proceedings. It's an administrative hearing that actually has no binding. So in 1985, the DEA held a ALJ hearing on the scheduling of cannabis. The judge at the time found that cannabis was safe and that it should be Schedule 2, and the DEA decided they didn't need to listen to their own their own judge. So this is sort of a it's not necessarily a required process, but it's a process that the DEA can ultimately decide what they want. And so the next step after this hearing would be that the DEA would make their final determination. So they would say, okay, we've heard everything, we've heard the public comments, we've heard expert testimony, and now we have decided that we agree with the Department of Justice that it should be Schedule 3, or they can say they disagree and say it should be Schedule 1 or 2. And so when they make that determination, there's a 60-day period for judicial review. And this is when people can file lawsuits challenging their findings, challenging the process. And historically, those challenges have not been successful. What happened was for this hearing that was supposed to start next week, the DEA posted a notice saying that they'd like people to sign up, to if they were going to be harmed by the Schedule 3 ruling. But then what was unclear is that, and this is where the current judge was kind of confused, was that the DEA selected witnesses that would both be harmed by Schedule 3. And so those are the groups, there were a lot of law enforcement, drug testing organizations, organizations like SAM, and other anti-marijuana groups. But they also chose a handful of groups that wanted to see rescheduling. And so this is where the judge was confused. And so one of the groups that is for rescheduling, actually a few of them pulled together with one attorney, and they were challenging the process that the DEA went through to set up these hearings. And so they filed a few motions basically saying that they had two arguments. One, that that the process that the DEA used to select who was going to be a witness in this hearing, um, that it needed to be exposed and they needed to explain themselves. And then secondly, they were challenging whether or not DEA should be the one holding these hearings. And this is, kind of where it gets a little confusing. So a lot of their arguments are interesting and intellectual, but, they're not really looking at the fact that this hearing actually doesn't have weight, the weight that they are saying that it does. So this was the second motion of this kind. And this time the judge basically granted like a stay in the hearing. So basically the judge has stopped these hearings, he's postponed them while the this witness group actually goes into district court to have a district court weigh in on both whether or not DEA should be the one holding these hearings, and secondly, to dive into the process that they use to select the witnesses. So so for the time being, these are postponed, potentially waiting for what comes out of those hearings. And so, the ALJ, basically said that this group is actually asking um, uh, this judge to do things that are um, outside of what he has the power to do. But also, he's reminding this group, and so he calls them the motivants in this in his response. But he's basically saying that even if that he doesn't think that they're going to get the relief that they're hoping to get, right? That the process for scheduling includes the DEA. That the DEA, in the laws that were passed by Congress, this is the process that is there. And so, it's basically saying, good luck, but I don't think you're going to get necessarily what you want. But I think more importantly, what he points out is that, by blocking this hearing, uh, one, we've waited a long time for this hearing, so it's unclear how long this process is going to take outside of, outside an outside court to rule. In these sort of proceedings, the district court could rule, and then there could be an appeal. So this could take years, right? And so, that's one thing that Judge Miller pointed out here. But also, the DEA doesn't actually have to hold these ALJ hearings. So when we're looking at what happens next, so one outcome could be that these hearings are just on hold, and then we wait for the district courts to rule on the items that the motivants are asking. And then once there's whatever the conclusion is of those hearings, then we restart and reschedule the ALJ hearings. But the current administrator could also just make a final ruling and say, we're not going to have ALJ hearings. There will, we've decided that cannabis is a Schedule 1, Schedule 2, Schedule 3. And then from there, we would move into the judicial review period. And so, what the judge also, I think a lot of the reporting has talked about, how the judge is definitely annoyed with the DEA. And I think what's kind of hard to understand, if you haven't been following this process for the last 50 years, is that and this is my sort of reading of the tea leaves, is that the DEA was using these ALJ hearings as a way to create a record for the eventual judicial review. So, a lot of the anti-cannabis groups, when the Department of Justice said that they were, agreed with HHS that cannabis should be Schedule 3, that they were going to sue. I think a lot of pro-cannabis groups, if they, if DEA comes out with Schedule 1 or Schedule 2, they're going to sue. And so in the process of selecting people to testify in this hearing, it seemed like the DEA was picking, basically creating a platform for people that they thought were going to sue them to sort of give them, the information they were going to use in a judicial review during this process. And so in a ALJ hearing, I mentioned this before, the people that participate are supposed to be people who have standing or interested parties, meaning that if the government moves forward with a ruling, that they would be harmed for whatever reason. And so for drug testing companies, they were saying, if cannabis is Schedule 3, then there will be no requirements for drug testing. And so uh, that will hurt their business. And that may sound silly, but financial impact is a reason to show standing, so that they can make the case of why they think cannabis should not be rescheduled. Some of the other sort of anti-cannabis groups, one of the reasons they had standing, they proved standing, was that they would have to change all their educational materials. In previous rescheduling processes, Americans for Safe Access, we were actually granted standing because one of our members, Michael Crowitz, is a veteran, and because of cannabis's Schedule 1 status, veterans actually have to pay an out-of-pocket cost to go to seek medical care outside of VHA. So that's a normal sort of a way to define standing. And in the ALJ proceedings, this is supposed to be an airing of people that would be impacted by Schedule 3. And so what's confusing is that the DEA isn't necessarily a proponent of the Schedule 3, right? They actually don't necessarily agree with HHS. And so the fact that they selected both people that would be harmed by Schedule 3 and people that would be harmed by it remaining Schedule 1 made the whole proceedings convoluted. And so that's what really annoyed the judge. Then, they were also trying to get things into the record, like how they analyzed the public comments. And, the judge kept saying to the DEA, we don't want to hear this. This is not an appropriate place for this. So the judge was definitely annoyed with I think he even said the arrogance of how the DEA was conducting themselves in this hearing. But the judge was also annoyed with the motivants for not understanding the breadth of what these hearings mean, and that they would be that they were kind of using these hearings for like an intellectual exercise, rather than creating a place where these issues could be brought forward and the process of rescheduling could move forward. So in the case that the DEA comes back and just says, okay, we're not going to have an ALJ hearing. We are just going to make our ruling. That would then set the clock for the 60-day judicial review. And so the cannabis would remain Schedule 1 or whatever their determination is until that 60-day pass. And then whatever the scheduling is that the DEA has determined, that would be the new scheduling. So if people want to get more history of sort of what's happened to now, you can check out ACE's blog, where I'm going to be putting up a blog right on Friday that will have all of the proceedings. So if you want to actually dive in and read all of the documents, the back and forth, between the judge, the DEA, and the motivants. Um, I think it's also sort of remind people that, no matter what happens through this process, through the rescheduling process, as medical cannabis advocates, um, we really got what we wanted out of this process in that the two top health agencies and the Department of Justice have confirmed that there is accepted medical use of cannabis in the United States. And we have never felt like any of the current schedules actually are going to work for medical cannabis. And in the event that DEA does confirm Schedule 3 or even says Schedule 2, none of that is going to have an impact on patients' daily lives or on the current medical cannabis programs. These programs are operating completely outside of the Controlled Substance Act. So in a sense, it doesn't really matter what schedule cannabis is, they're still going to be operating illegally. So for instance, a Schedule 3 drug is defined by something that's actually gone through an FDA drug approval process, and someone has the permission from the DEA and the FDA to sell that substance. So there are still criminal penalties involved with unregulated Schedule 3 substances. So for instance, people who sell codeine, people who make purple dank, those products, those are not legal. And so there was always going to need to be congressional action. So, the other thing I want people to realize is that, the proposal that the DOJ has made is not just a pure rescheduling proposal. So they did say if they wanted to move the term marijuana and marijuana extract into Schedule 1, but they're also leaving various THCs in Schedule 1. And they actually created a new definition for THC delta 9. And this is going to play out in this year in the Farm Bill and in other legislation. So this wasn't just a pure all of cannabis and cannabinoids would be Schedule 3 or Schedule 2, whatever the DEA determines. And so the actual, if this if the as written moves forward, we would see some cannabinoids would stay in Schedule 1, some would be in Schedule 3. It looks like CBD may, depending on where it came from, could be Schedule 3 or could potentially still be descheduled based on whatever comes out of the Farm Bill. And so, this is not really a surprise, right? That we are going through these hearings, or that the DEA, wasn't in line with what the Department of Justice had proposed. It was very clear if you read those documents that the DEA during the whole process basically was questioning, how HHS came to these conclusions. And so, this whole process may not be how we get to where we want to be anyway. And, we certainly, have never thought that the DEA was going to be the place where we would get resolution for medical cannabis. And so again, the hearings that are happening right now, these are based on the process that's laid out in the Controlled Substance Act. And so the DEA had requested these hearings, but it's an internal hearing process. So, whatever happens in the courts that the motivants have put together, the findings from that process isn't going to be about the scheduling. It's really about this process. And so again, everything's sort of put on hold until we hear back. So the other thing that I want to point out to folks is that there's been ideas of what what are some other sort of factors that could happen around the rescheduling. And last year in the House subcommittee of the CJS appropriations, which is the subcommittee that determines the budget for the Department of Justice, House Republicans actually passed two amendments to their budget. And one was actually to stop the rescheduling efforts altogether. Now, the last Congress didn't actually pass appropriations bills. They punted them to this next year through something called a continuing resolution. And so all of these amendments have been wiped clean, and we're starting over in the appropriations process with the new Congress. But I think something that was alarming was that House Republicans did pass something, in their version. It didn't make it to the Senate last year, but that would first stop the rescheduling process. But they also modified our medical cannabis amendment. That is what has stopped Department of Justice raids since 2014. And what they added was actually language. They just amended our amendment, as you can see here, that actually opened the door for federal interference in state medical cannabis programs, specifically in special use zones. So you've probably heard of drug-free zones, and these are sort of special in our state programs. There's special restrictions that would keep a dispensary or a manufacturing site or a cultivation site within 1,000 feet of certain special use areas. In most of the legislation, it may not be 1,000 feet. Maybe it was 500 feet. But it's definitely what we have in the state legislation is definitely not as restrictive as what is in the Controlled Substance Act. That includes not just schools. I think in a lot of the state versions, we have elementary schools, high schools, but the federal version includes junior colleges, universities, housing facilities owned by the Public Housing Authority, but also swimming pools. Because this was written in the 80s, it includes video arcade facilities. But what is really concerning is that any violation of the Controlled Substance Act within these parameters includes a double fine and a double punishment. So, there are a lot of mandatory minimums around cannabis distribution or manufacturing. So if something, was a 5-year mandatory minimum, if you were doing that activity within these zones, it could be a 10-year mandatory minimum. And so this is sort of a crack in the protections that we've created. And then, within this president, there was, a lot of his advisors, have kind of put their vision of America forward in a document called Project 2025. If you haven't read the 900-page document, don't worry, I've pulled out some of the components that are worrisome for medical cannabis, but they're actually, talking about having the federal government intercede in states, that have laxed policies around drug enforcement. And so, we know that around this president, there is sort of this want to correct, states that have moved forward with decriminalization, even for patients. And, last year, the Democrats had the Senate, or control of the Senate. And so I think maybe people weren't as worried about having something pass in the House version of that bill. But with the new election, with the Republicans taking over the Senate, what's worrisome is that the sort of last of the very anti-cannabis members of Congress, they're now in leadership. And so the day after the House passed the CJS amendments, there was a letter that was sent to the Attorney General that was signed by 25 Republicans. And with the change in leadership from this election, 5 of those signatories from that letter are now in key positions that are going to that could impact our protections. Thune is now Senate leadership, so that's going to make any bills that would help us, sort of a challenge of getting heard on in the Senate. But I think more concern is Jerry Moran is actually going to be the chair of the appropriations of the CJS committee, which means that, if the House passes that amendment again, the Senate could easily pass a version and we could start seeing a pushback on our rights. So I'd like everyone to sort of tune in and sign up to work with Americans for Safe Access. We're going to be launching a campaign focused on getting some rights for patients within the power of the president, our 100 Days campaign. I think a lot of people were thinking that Trump can kind of step in and fix all of these rescheduling issues because of things he said during the election. But the truth is he has no power over the Controlled Substance Act. So what Biden did as president, where he called on HHS and Department of Justice to do a review of the scheduling, that is the extent of the power that the president has to intervene in scheduling issues. Now, Congress at any time can pass a law and change the scheduling of cannabis. And that's what we're hoping they'll do. We will be introducing the Medical Cannabis and Cannabinoid Act this session of Congress, which would actually create a new schedule for cannabis. And so we're asking folks to sign into that campaign. You can visit our website, safeaccessnow.org, and look for the Safe Access for All campaign. Your organization can endorse. Individuals can sign this petition. I think the key to where we are right now is that with these hearings being postponed, in a way, this was really just a process that we had to watch unfold, but it doesn't really change anything that patient advocates were doing. Our final victory is gonna have to happen through Congress passing a bill. If you'd like to hear more about sort of patient impacts around scheduling, we have some webinars on our YouTube channel. So this is where you can find a recording of our Lunch and Learn, and we'll be posting those each week. You can learn more about our legislation at safeaccessforall.org, or just go to our website and look for the Safe Access for All campaign. And I want to remind people that there is bipartisan support for medical cannabis. We just have to put forward a proposal that is going to make sense to folks. And I think that this is going to be the year of medical cannabis, but it's going to take everyone. We know that our proposal isn't crazy, that actually we're hearing the Congressional Research Service has actually said that it is possible to create a new regulatory framework for cannabis, and that creating another schedule for cannabis is also in the purview of Congress. So I hope you guys will all sign up, join in. If you're not a member, please join. And let me see if I can see the questions here. Okay, let's see. I have to come to here. Okay, I don't see any questions in the Q&A. So I just want to say thank you all for tuning in, and I will be here next week with another exciting, relevant topic. If you guys have ideas of topics you'd like us to cover, you can send in requests at info@safeaccessnow.org. And again, thank you all for joining today. And I guess if there's anything I would say about this whole proceeding is that it's going to get messy, but what's what I hope everyone knows is that these hearings, this process with DEA is not how patients are going to get safe access, that our work is with Congress. So as entertaining as it can be to watch these back and forths, we need to stay focused and make sure that you know where your representatives stand on medical cannabis. Have a great day, everyone, and I'll see you next week.